4, the respondent be directed to allow the applicant to remain in the official post of national head of the DPCI on terms and conditions not less favorable to those which existed prior to the granting of the order by the full court on 12 April 2017, enforcing its main judgment delivered on 17 March 2017, pending the outcome of the appeal to the Supreme Court of Appeal against the order granted by the full court on 12 April 2017, enforcing its judgment delivered on 17 March 2017. Lastly, that the first respondent be ordered to pay costs on the application de bonis propries, and the other respondents pay the costs only in the event of opposing the application. As a waiver background, on 17 March 2017, the full bench of this division, comprising of Judges Mabuse, Kolopen, and Bakwa, reviewed and set aside the appointment of the applicant as national head of the DPCI by the erstwhile Minister of Police. On 12 April 2017, the same full bench dismissed the applicant's application for leave to appeal, and after dismissing the application for leave to appeal, the main application, the court granted the counter application for enforcement of the court order under the circumstances where there was no pending appeal. In upholding the counter application, the full bench ordered that, I quote, the operation and execution of the order granted by this court under case number 23199/16 on 17 March 2017 is not suspended and will continue to be operational and executed in full, whether or not there are any applications for leave to appeal and appeals, or there is any petition for leave to appeal in respect of this order. On 13 April 2017, that is a day after the full court granted the order, enforcing its main judgment granted on 17 March 2017, the applicant filed a notice of appeal to the Supreme Court of Appeal against the judgment delivered by the full court on 12 April. That is the enforcement order. The applicant maintains that, as stated in subsection 4, Roman figure 4 of section 18 of the Superior Courts Act, the filing of the notice of appeal has automatically suspended the order granted by the full court on 12 April 2017, pending the outcome of the appeal against such order. According to the applicant, the wording and terminology used in paragraph 2 of the enforcement order is irrelevant, because the section creates an automatic right of appeal against the enforcement order, irrespective of its wording or terminology. That is the wording and terminology of the enforcement order. On the other hand, the respondent maintains that the entire issue of whether the provisions of section 18 subsection 4, Roman figure 4, would apply with effect that the order would be automatically suspended has been addressed by the full court, which has granted an order that is binding on this agent court. The full court's order plainly stipulates that both the order in the main application and the order to execute the main order pending appeal will not be suspended, regardless of whether or not there's an appeal. Therefore, the respondent maintains it is not for this agent court sitting with a single judge to overturn a decision of the full court. If the full court was wrong, that is a matter to be addressed with the Supreme Court of Appeal and not this agent court. It is incompetent to seek to undo the clear findings of the full court in this court. According to the respondent, the clear meaning of the latter part of the order is that the consequences of the 17 March 2017 order will remain in place, not only if the applicant is to appeal, petition, or otherwise seek to set aside the 17 March 2017 order, that is the main application, but also if the applicant were to appeal, petition, or otherwise seek to set aside the 12 April 2017 order, that is the enforcement order. This much is clearly stated in the order by the full court using the phrase, I quote, in respect of this order, close quote. The respondent submitted further that whilst he understands the default position in respect of section 18, subsection 4, Roman figure 4 of the Act is that the enforcement order is suspended once an appeal is lodged. He submitted, properly interpreted, the order handed down by the full court on 12 April specifically altered this default position by recording that the enforcement order would remain in place even if it were to be appealed. For that reason, section 18, subsection 4, Roman figure 4 of the Act has no application in this matter. I agree with the respondent. The wording of the order of 12 April 2017 is very clear. I'm therefore satisfied that the words in issue, I quote, in respect of this order, relate to the order of 12 April 2017. The enforcement order was handed down after the full court had dismissed the application for leave to appeal the main application. In arriving at its decision on the counter application, the full court noted that it was not in dispute that in the severe judgment, the applicant was found to have been dishonest, dishonorable, and to have acted in bad faith and for ulterior motives. The court also noted that a petition to the Supreme Court of Appeal for leave to appeal against Judge Matojane's findings was dismissed, and there was no further appeal against these findings. The court, the full court, stated that in the light of the severe judgment, the applicant lacked the fitness and propriety necessary for public office, and that he should not be permitted to continue as the national head of the DPCI. The court pointed out that the applicant's dishonesty and lack of integrity permanently disqualified him from being appointed to any public office. The court further stated that it cannot allow a person it regards as unfit for any public office to continue in high public office for 1 day longer than is necessary. And on regarding the issue of whether or not the full court was correct in granting the enforcement order under the circumstances of this case, this court is not competent to pronounce on the issue whether or not the full court was correct in granting the enforcement order under the circumstances where after dismissing the leave to appeal. Moreover, the purpose of section 18.4 is to prevent irreparable damage being done to the aggrieved party. In this application, the applicant stated that he will suffer humiliation, loss of reputation, and be deprived of the opportunity to work. However, he has failed to establish that such harm will be irreparable. In my view, the interest of justice in this matter far outweighs any harm that may be suffered by the applicant. Moreover, his appeal is scheduled to be heard by the Supreme Court of Appeal on 2 June 2017. On the issue of agency, the applicant is obliged to set out clearly the circumstances which render the matter urgent. More importantly, he must state the reasons why he claims that he cannot be afforded substantial redress at a hearing in due course. The applicant contended that the matter was extremely urgent as envisaged by the provisions of subsection 4, Roman figure 3 of section 18 of the Superior Court Act. This contention is clearly misguided, as subsection 4, Roman figure 3 requires the court hearing the appeal, in this instance the Supreme Court of Appeal, to deal with this matter as a matter of extreme urgency. The applicant is currently earning his full salary, and further he's currently not performing any functions attaching to his employment, and has failed to show that he will suffer any serious prejudice by not having a work phone or a car provided by his employer. Further, as already mentioned, the appeal is already scheduled for hearing by the Supreme Court of Appeal on 2 June 2017. This will afford the applicant an opportunity to speedily obtain substantial redress if he is entitled to any. Having regard to the findings I made in this judgment, I am of the view that this matter is not urgent and should be struck off the roll. I accordingly make the following order: that the matter is struck off the roll for want of urgency, and the applicant is to pay the cost of this application, including the cost of 2 counsels. That's my order. The court will adjourn.